Today on BenchBriefs, we're looking at a fascinating case from the Federal Court of Appeal that dives into the intersection of competition law and constitutional rights. The case is Canada, Commissioner of Competition vs. Amazon.com CA ULC, decided in 2026. It raises important questions about how federal competition rules apply to major online retailers like Amazon, and what happens when those rules bump up against constitutional protections like mobility rights. So, what's this all about? The Commissioner of Competition, who is responsible for enforcing the Competition Act, initiated proceedings against Amazon's Canadian subsidiary. The commissioner alleged that Amazon failed to comply with a specific part of the Competition Act, Section 11(2). This section deals with requirements that certain parties must follow when the commissioner is investigating potential anti-competitive behavior. The case also involved interpreting several other sections of the Act, Sections 11, 1, 12, 13, and 14, which together set out the framework for investigations, notices, and requests for information. At its core, the dispute was about whether Amazon met its legal obligations during a Competition Bureau investigation. But there was a twist. Amazon challenged the constitutionality of Section 11(2), arguing that it violated their mobility rights under the Canadian Charter of Rights and Freedoms. Mobility rights, found in Section 6 of the Charter, protect Canadians' ability to live and work in any province. Amazon's argument was that the specific demands placed on it by Section 11(2) interfered with its right to pursue a livelihood across provincial lines. The case also raised a procedural issue about the standard of review. When courts review decisions made by administrative bodies like the Competition Bureau, they have to decide how much deference to give to those decisions. Should the court apply a highly deferential standard, trusting the expertise of the administrative decision maker, or should it take a more hands-on approach, scrutinizing the decisions more closely? This question was central to how the Federal Court of Appeal approached the judicial review of the Commissioner's decisions under the Competition Act. Let's break down the key legal issues the court had to decide. First, did Amazon comply with Section 11(2) of the Competition Act? This section essentially requires certain parties to provide information or documents when requested by the Commissioner during an investigation. The court had to interpret the scope and application of these requirements and assess whether Amazon's actions met the legal standard. Second, was Section 11(2) constitutionally valid? Amazon argued that the section infringed on their mobility rights by imposing obligations that effectively restricted their ability to operate freely across provinces. The court had to consider whether this section of the Competition Act unjustifiably limited a charter right, and if so, whether such a limit could be justified under Section 1 of the Charter, which allows reasonable limits prescribed by law. Third, what standard of review should apply when courts review administrative decisions under the Competition Act? This is a technical but crucial question. The court examined whether it should apply a standard of reasonableness, which is more deferential and respects the administrative expertise of the commissioner, or a correctness standard, which involves the court substituting its own view for that of the administrative body. In its decision, the Federal Court of Appeal carefully analyzed all these points. It found that Amazon had not complied fully with the requirements of Section 11(2). The court emphasized the importance of these provisions in ensuring that the Competition Bureau can effectively investigate and enforce competition law. Without such cooperation, the Bureau's ability to protect consumers and promote fair competition would be seriously undermined. Regarding the constitutional challenge, the court acknowledged the importance of mobility rights, but concluded that Section 11(2) did not infringe those rights in a way that was unjustified. The obligations imposed on Amazon were found to be reasonable and necessary to fulfill the government's legitimate interests in regulating competition. In other words, the law struck an appropriate balance between individual rights and the public interest. Finally, on the standard of review, the court confirmed that a reasonableness standard applies to administrative decisions under the Competition Act. This means courts should generally defer to the expertise of the Competition Bureau, intervening only when decisions are clearly unreasonable or lacking justification. Why does this case matter? For one, it reinforces the authority of the Competition Bureau to conduct investigations and demand information from major players in the marketplace, including global e commerce giants like Amazon. It also clarifies that competition law provisions can withstand constitutional scrutiny, even when they intersect with fundamental rights like mobility. This balance is crucial in a modern economy where businesses operate across provincial and national borders. Moreover, the case provides guidance on how courts should approach reviewing administrative decisions in the competition law context, reaffirming the deference owed to specialized regulatory bodies. This helps ensure that complex economic and legal issues are handled by those with the right expertise while still preserving judicial oversight. In summary, Canada, Commissioner of Competition v. Amazon.com, I say, is a key decision that highlights the ongoing tension and necessary balance between regulatory enforcement, constitutional protections, and administrative law principles. It reminds us that the law must adapt to the realities of a digital and interconnected marketplace, all while respecting the rights enshrined in our charter. Thanks for listening to this episode of Bench Brief. Be sure to join us next time for another deep dive into Canadian legal decisions that shape our world. Until then, take care.